Okay, it's a couple of minutes past 12, so I think we'll start, if that's okay with everyone.
Yep. Yeah, no problem at all.
So SJ, thank you very much for joining. I met SJ through a program called the Goldman Sachs 10,000 Small Business Course. So we are regularly at kind of alumni events together. SJ also helped me out when I was in a bit of a pickle at the beginning of this year with a very quick new lease for a move that we had to do on our premises. So I've got kind of first-hand experience of her team working and assisting us with that process. So we've, as you know, we've kind of covered a few different business-related topics in these webinars. So we really thought it'd be useful to bring together the legal side. So I'll let SJ kick off.
Cool. Thanks, Nicola. Yes, hello everybody. My name's Sarah Jane Butler and I'm the founder of Farringford Legal. Today I'm just going to have a canter through legal support for growing and scaling your business, and then ultimately with the mind's eye on planning an efficient exit. Now, just to give you a bit of detail, so this is who I am. I've been a lawyer for, gosh, I'd say the last 25 years. But now, having worked in the city, I now focus purely on small, medium businesses because effectively their commercial legal needs are way more interesting, to be quite honest, than most other people's. But equally, they're the ones who need the most support and understanding about what's going on. So I opened Farringford Legal 3 years ago, inspired by the Goldman Sachs Small Business Programme, really to help and support small businesses build the right foundations. So this is who we are. This is the areas that we cover. So corporate, commercial, banking, finance, employment, data protection, HR. We also cover tax as well, and trademark and IP. So pretty much anything that you might need within an SME. Now, today, we're really going to focus on understanding the right foundations. Now, some of you are probably way beyond this phase, but actually bear with me if you're saying, hang on a minute, teaching grandmothers to suck eggs here. We know all of this. We've been in business for a while. Actually, what you start with at the very beginning really makes a massive difference when you're looking to exit at the end. And having those right foundations will make it much easier to attract a buyer or yourself to attract businesses that you want to buy. But equally, it will massively help with the whole process and ultimately, if I'm being really honest, be cheaper. So especially from a legal fees perspective, which after all, nobody wants to pay legal fees. So setting up the right foundations really sort of covers 5 key areas: your vision and your strategy, target market identification, competitive analysis, and an agile business model together, and very crucially with legal compliance. So in short, your vision and your strategy comes down right to the very basics of, for example, what kind of business are you going to be running as? Are you going to be a sole trader or a limited company? To cut ahead and let the cat out of the bag for one instant, if you are a limited company, it is much easier to sell your business because you have the options of both shares or asset sale. I'll come on to that a bit later. Equally, your target market identification enables you later on to identify prospective buyers or prospective acquisitions who are within your target market. So having a clear defined element of knowing who your customers are, your market size, and where you wish to expand into is really key. Clearly knowing who your competitors are is important. Number one, because you want to stay ahead of the game, but equally those competitors might equally be your future buyer, and being in line with them is key. One of the things I always say is keep your friends close but your enemies closer. And I think the same thing applies with your competitors. Understand where they're at and keep close to them, because you never know in the future they might actually be your future acquisition or your future purchaser. Your business model, I think that stands to reason. You need to make sure that you are agile and flexible, especially in these days with AI, etc. You need to be very quick to respond to how the economy and political situation is working. And then finally, just looking at legal compliance, this is really a non-negotiable, and I would say that because clearly I'm a lawyer, but it is really important that you have the right legal foundations in place. That means if you are in business with somebody, please make sure you have a shareholders agreement. You have no idea how many problems arise upon a sale where there is no shareholders agreement and there are multiple founders in place. Equally, you must really make sure that you have proper contracts in place with your suppliers and your clients, because when you're undergoing a due diligence exercise, those are the first things that any possible purchaser in the future is going to want to look at. So one of the key things is really finance. Obviously, most of this, and I don't wish you to suck eggs, is quite obvious. Making sure you have a robust financial system in place, you know how your cash flow is managed, you have an eye on what the funding options, and clearly you know where cost controls are coming in, is really important, because part of the due diligence that any purchaser is going to undertake will be looking crucially at your financial infrastructure. So they will want to know what your accounts look like. They will want to have an understanding of at least the last 3 years of business P&L, what's happening on your balance sheet, what's hiding behind it. And they won't just take what you've shared on Companies House, they will take your actual full unaudited accounts. They will want to know, in terms of payment flows and cash flows, where the money's coming in from your clients and what the payment terms are, for example. Equally, they will want to know what, if you have any loan agreements, they will want to know what the payment terms of those are. So all of these things are really crucial when you're scaling, but equally making sure that you've got them all in place when coming to sell is important, because any future buyer is going to want to look at and trawl over all of these elements. And they will also want to know that they've got clear operational control over any of the documents or loan financing that you've put in place. By the way, whatever I say for when it comes to selling your business, equally it applies to anyone who's looking to acquire a business. These are the sort of things that you need to be looking at and thinking about when you're looking to acquire a business. And that clearly means things like, do they have proper financial operations in place? Have they got records and data with regard to each of their suppliers and their employees and their clients? All of those things are things that you should be looking at when considering whether you're going to purchase a business or not. Moving on to the actual operational side of it, as you grow, clearly operational efficiency is absolutely key. You are not a one-man band anymore. You are now expanding out. You will have lots of different elements to your business, from operations to HR to tech, and so on and so forth. And you'll need to make sure that that is all very clearly aligned and processes very clearly set out. I think one of the key things that we learned as part of the Goldman Sachs program is really having all those processes in place. So imagine that you're not there anymore. Can somebody just come in and run that entire business without you being there, without it all being in your head? And that is a really key to any scaling that you are aiming to do, and also really key for any purchaser who's coming in, because they may not want you, they may not take you on board as part of the acquisition, but what they will want to know is, how does the tech work? You know, what are the processes in place? What is the supply chain? Where is the inventory? Do you have very clear parameters and contracts and databases in place? So they will want to know all of those things. They will also want to know, very crucially, things like your IP. So as a founder, one of the key things that you put into the business is your IP. But if you don't have a director's service agreement, actually that IP doesn't belong to the business. It only belongs to you. So they will want to know that you've assigned all your IP and all your ideas so that it actually genuinely belongs to the business. And that is why you often see in employment contracts, you'll see that there are intellectual property and confidential information clauses. These are there really to protect the business, so that those employees don't take anything that they've created as part of their employment and disappear and use it somewhere else. They will also want to know clearly that you've got, with any supplier agreements, that they've got dispute resolution, quality standards and legal protections in there to ensure any business continuity post sale. By the way, stop me at any time if I'm kind of rushing through this. The reason I'm trying to sort of build out both the operations, the finance, all of that side of it, is that you will see that each of these elements are, as you scale, provides the framework and the foundations for actually selling in the future. So this is, I think, very, very key to anybody who is trying to create a proper growth culture. Especially if you're selling the shares of your business, your employees will go along with them, so with the business. So you obviously want to have a company culture that is very positive. You want to have training, you want to have employees, because any purchaser is not going to want to restart again. They're going to want to know that they've got loyal employees who have been trained, who know how the business works, who can carry it forward in that integration process. They will want to know that there are proper governance structures in place, and that the leaders that are left behind after the sale know exactly what they're doing and clearly have their role. Sorry, Nicola. Yeah, so your hand's gone up.
Are you happy for questions as we go? I didn't
Yes,
ask.
yes, I'm more than happy. Yeah, do ask me questions as we go.
The interesting thing in our market, as a bit of a nuance, is there is a bit of a consolidation happening. So some of this is really some becomes really interesting, and it doesn't mean anyone shouldn't have this in place, but there's some interesting buying happening. Some is like a build and buy, so they've already got kind of a platform, and that they're trying to kind of bolt on more practices. Others, they're like entrepreneurs coming into the area, into the space from different markets, and are trying to do a buy and build from scratch. Does it differ if you like, is there a particular size of business where this becomes more relevant or less relevant, do you think?
No, not really. I think whether you're trying to build and buy and build, or whether you're coming in from the outside, when it comes to a sale or even an acquisition, you will have a data room, and within that data room, online data room, will be all of this information. And the due diligence exercise is the really key way for a purchaser to understand exactly how the business operates, what its finances are, what's its employment situation, does it have any claims against it, for example. And that is really important at whatever level, whether you're, whether you're buying your first business and it's a £50,000 business, or whether you're buying your third business and it's a £5 million business. Clearly there's more in a £5 million business. That due diligence exercise is really, really important. And the more organized a company is with all of its documents, the easier that process is. Because it's a bit like, the way I describe it is a bit like walking into my daughter's bedroom. Okay, I have two daughters. If I walk into one daughter's bedroom, it's always really clean and everything's where it needs to be, and I can put things away or I can take things out of it, and I know exactly where I can find things, and it's all good. If you walk into my other daughter's bedroom, it's an absolute pigsty. I can't find anything. I don't understand anything. I can't find what she needs. So if she's lost something, well, it could be anywhere. And that's a strange analogy for when you're going into a data room, because if things are missing, you're going to start asking for it. So it's going to delay the process. If your finances aren't in there, or they're a mess, or they don't make any sense, then actually what it does is it puts off anybody who might be wanting to buy you, because they're like, well, that loan's not in there. It seems to be on the accounts, but the loan documentation isn't properly done. Or quite often what happens is they've got a supplier agreement relationship, but actually there's no services agreement there. They've just got an NDA. Now, an NDA does nothing. It doesn't oblige you to do anything. So you could lose one of your major suppliers because you actually don't have a service agreement in place. So the level of due diligence you do grows as the company size grows, but the importance of having everything in order and being organized is exactly the same whether you're at the beginning or the end. And the problem with doing it, if you're not organized and you don't have it in place, then actually the amount of time it takes to put things right, the amount of legal cost it takes to put things right, tends to either put people off, Because if it's nice and simple and easy, they'll go through the process, and then you get to the SPA and it's all great. If it's taking a really long time just to understand how a business operates, it compared to another business that might be really organized, they're going to go for the one who's really organized. Does that answer your question?
Yeah, completely.
Yeah.
Just kind of giving context to people as to when to think about this, but really I suppose the essence is think about it from right at the beginning when you're setting up, or as early as possible if you're already set up and trading.
Yeah, it's very difficult, because when you're starting, it's really sort of super exciting, and you're setting up a business, and you want to get everything in place, and you just want to get on with trading, and you just want to do stuff. I think the reality is that you know, with the best will in the world, it's one of these things that you think about afterwards. And not everybody thinks about, and let's face it, nobody really wants to spend money on lawyers to put all this stuff together, because they're like, well, I'll do it when I've got a bit more money, and then I'll sort it out. So it, obviously from a legal point of view, the sooner you can get this in place, the less problems you will have in the future. But also from a commercial trading point of view, I also understand how this works, because you just want to get on and do your business, and sometimes it's a kind of like, oh, I should have done that, damn it, I should have done it in the first place. But I think where you are preparing for a sale, understanding the groundwork that I've just explained in the first few slides means actually the rest of it will be much smoother and much more efficient than if you didn't have this stuff in place. And it's, I think there's definitely that mantra. If you fail to prepare, be prepared to fail. It's one of those things. When you're thinking about selling your business, then I would definitely think about spend a good 2-3 months putting everything that you need to put in place, so it's all there, and then go out to try and find a broker and to sell the business. Or equally, if you're acquiring it, take the time to really understand the business, and if necessary, and obviously put an NDA in place so you can discuss it with the business. But the more time you take to understand it and continue and do your due diligence, actually the much smoother the operation will be when you actually come to sale, because you can sell if you've got everything in place, you can sell incredibly quickly. It can take 2-3 weeks. If you don't, it can take 2-3 months. So that's the kind of differentiation. So just sort of looking back on the slides that I've just said, in terms of vision and strategy, which was my first slide, if you've got a clear long-term strategy, it not only guides your growth, but also clearly sets out to any purchaser what you're all about, and equally, it means that your focus is very clearly set out from the outset. So when a business is aligned with its goals, it's much more attractive to a buyer, so it allows for a faster sale process. Equally, with your financial infrastructure, if you've got a strong financial system that complies with legal standards, it's going to reduce the likelihood of any red flags coming up during due diligence. So if all of your invoices are properly reconciled, if your payment terms are all properly in place, your loan agreements are all properly in place, that will mitigate any of the risks or any of the red flags that might throw itself up in the due diligence process. With regards to scalable operations, if you've got a very clear compliant operations framework that covers employment, data protection, supply chain agreements, and they're all in place and they're all enforceable, that's like a bouquet of flowers to a buyer. They're like, perfect, everything's in place, everything's organized, and it reduces the need for any last minute legal cleanup, as I said. So that clearly then avoids any further delays with regards to due diligence or negotiation. If you have to suddenly put contracts in place with your directors, if you suddenly have to make sure all your IP is properly assigned, or that you've got tech supplier agreements in place that actually reflect how you're working, that will take the time, but be likely to cause disputes, because trying to push things through at the last minute tends to not go well, if I'm being really honest about it. And then the final slide that I said before, which was about growth culture, again, if you've got proper governance structures and employment contracts in place and handovers and all of that kind of thing in place, it gives any potential buyer a lot of confidence that actually they're not going to have any employee related issues coming up once they've actually bought the company. From a sort of boring point of view, you've got asset sales and share sales. Now, asset sale is obviously what it says. You're just buying an asset. So whether that's a warehouse or a book of clients or whatever that means, that is a very ring-fenced process. And you know exactly what you're getting, and you have less of a downside on that. So the only issue that you probably need to be slightly aware of is 2P regulations if you are potentially dealing with transfer of assets that involves operational employee processes. But we can discuss that. The share sale, when somebody buys the company, they're buying it warts and all, so absolutely everything. So your debts, your liabilities, your pros, your cons, absolutely everything. And this is where the due diligence process really, really is important. And if your legal groundwork is not solid for either an asset sale or a share sale, that's where you might be open to either the deal could fall through entirely, or you probably end up at a risk of litigation somewhere in the future, which is why having all these warranties and indemnities and proper contracts in place is really important. Sorry, Nicola.
Me again. What's the benefits for the seller or the buyer versus an asset and share? So I know there's a tax implication, but from a legal perspective, do you give any thoughts?
It really depends on what you're trying to get rid of. Not get rid of, sorry, what you're trying to sell. If you're trying to sell, if you've got a warehouse and which is an asset and you're trying to sell, it's a bit like buying a house. So you have, how do I put this? So obviously you have to take your due diligence and make sure that you've got warranties, indemnities in place, that the warehouse isn't going to fall down or something's going to happen. But it's a very ring-fenced. You're only dealing with one asset. So if you're buying, I'm just trying to think, if you're buying an IT system or you're buying like a book of work or a book of clients. So in your field, if you're buying, somebody's got a specific practice and you're buying all the equipment from that practice, there will be certain warranties and guarantees that you have to give with regards to that. But it's a fairly straightforward process. I said the only slight wrinkle to it is where you have to deal with employees and 2P regulations, because they might be transferring continuity of employment from one business to another. With the share sale, you're taking on everything, absolutely everything. And where somebody's looking to leave the industry entirely and just get out, from a seller's point of view, you'll want to just get rid of the whole thing because you don't want to be left with the shell of the company. So you'll want to sell absolutely everything, and with that goes all your client contracts, and nothing has to be. If you buy the shares, you're buying the whole lot. So you don't have to transfer or novate any of your contracts. You don't have to change any of your employment agreements. You're buying the whole thing, lock, stock and barrel. So you're literally just picking up the shares and putting it into your bucket. Does that make sense? Whereas with contracts, you'd have to novate them if you were to do an asset sale. So if you were to buy a book of clients, for example, you'd have to novate all of those individual clients one by one over to your business. Does that make sense? Yeah. So it really kind of depends. There's more work involved in a share sale, I'd say, especially with the due diligence. But afterwards, it's a lot easier to run.
Yeah. No, I just from experience, I've done 2 share sales, but I know that there is people doing the build and buy in this area that are wanting asset sales, are wanting asset purchases, but there's a tax implication for the seller as well, not getting the entrepreneurs 10% relief and things like that.
Now, clearly, that's probably all going to change in the forthcoming budget. But from a share perspective, you've obviously got CGT and business asset disposal relief, which is key for a share sale, whereas on an asset sale, you've got VAT and stamp duty. So those are the two elements to it. And from a tax perspective, what we spend some time doing with our clients is just looking at what's the most tax efficient way to structure an asset sale or a share sale. And with examples. So, and negotiating that deal structure is really important. So earnouts and or deferred payments also will come with sort of legal guarantees, but quite crucially, if you're the founder and you've got an earnout and you're staying in the business, there's a fine line between, are you receiving your earnout as a capital sale, or are you receiving your earnout because you're an employee? And there's two very different tax treatments. So if you're an employee and you're receiving £100,000, you're going to be paying income tax on it if it's determined that that's a payment to you as an employee now, or if you're getting an earnout, and is it CGT? So there's a very fine line between the two to structure that so it doesn't look like it's employee related income. If you're staying in the business, that is. So I think, yeah, there's sort of pros and cons to both of them. If you are buying an asset, as I said, it's a shorter process. There's less due diligence involved because you know what you're getting. But just in the same way as if you're buying a house, when you're buying a house, you obviously have somebody coming to do a surveyor, for example. If you're buying a building, there's lots of, I should say, sorry, with your buying or selling property, there's a further element to the land registry element as well. So you should be aware of that because you need to register. It's a conveyancing process. So that needs to be registered at the land registry. Whereas with a share sale, you don't have to do any of that because it stays in the name of the business, for example. Equally with a book of business, you would have to go through each of the contracts, but you'd have a tax element to it for each one of those businesses and the value of it. Nicola, do you want to go through any further elements on that?
No, it's fine.
Nope.
It's just highlighting the fact that people need to talk to someone who knows what they're talking about usually.
Yeah. So after all of that, what are the key legal considerations? Having said all of that, having said you've got to get your finances and your foundations and properly in place, where should you start? If you've sort of decided, right, I want to sell my business or I want to buy a business, kind of works both ways. Clearly, the first place is to start is a business valuation. There are so many different ways of valuing a business, and businesses like yours, like everybody within this group, it's very difficult. Depends how you value it, how you're being paid. Are you paying by dividends? Are you being paid by fees? How do you structure the business? How is it set up? So again, to sound like a broken record, it goes back to the foundations. They will look at various multiples of EBITDA, or they might look at various of net profit margin. Different businesses have a completely different way of being valued. So it's an actual art and a skill to getting a business valuation done properly. So I would really spend the time in getting somebody properly to look through it, and that will also form the basis of your proper financial due diligence, because what a business valuer will be looking at is the same thing as what a prospective purchaser will be looking at in order to understand the valuation of your business. So that's the first one. The second one is the due diligence, is preparing your data room. You don't need to get lawyers involved at this stage unless there are things that are missing. So unless you don't have the contracts, the shareholders agreement, the employment contracts, the IP assignment, you really need to, and we've got, Nicola, and I can share this with everybody, I'll share it with you. We've got a step-by-step guide of all the different areas that you should pull together when considering a data room. So everything from IP to employment to supplier contracts to finances. We've got literally a kind of a step-by-step guide of what should go into each one of those sectors, and you should very clearly organize your data room into those sectors and populate it as much as possible with as much information as you can, because the joy, maybe it's just lawyers because we're really sad, but the joy of literally having a complete wonderful data room all ready to go when you're looking to buy a business is just, anyone who's done this several times will know it's an absolute joy. You don't have to do all the hard work because somebody else has already done it for you, so it's a big tick. And then the tax planning, as I've mentioned, depends if you're an asset sale or a share sale, as Nicola said. Depends where you're looking at VAT or stamp duty, or whether you're looking at business asset disposal relief, entrepreneurs relief, etc., depending on what they change in the budget this year. And then you get onto the negotiation and the deal structure, and that's really where you need to start bringing in lawyers, and need to start sort of thinking about how the process is going to work through. So, how do we do the sales process? So many people who've already done this. So Nicola, you've already done this. You know how this works. The first is the negotiation phase, outlining the agreement and the heads of terms. I would probably say, and I probably would piss off a lot of my lawyer colleagues by saying this, but this negotiation phase is the most important phase. Now, heads of terms are not meant to be financially binding. Sorry, not meant to be legally binding. And that's quite clear, but there are a couple of elements where it really should be legally binding. The first element is confidentiality. So you do not want to be sharing your wonderfully organized data room with anybody else unless they have signed an NDA. So in your heads of terms, you should have a binding confidentiality clause. Second of all, you should have a binding data protection clause that they won't process your data or any data that they have received. It's always quite a good one, and it takes a little bit of negotiating, but it's always quite a good one to see if the other side will pay your legal fees if they abort. Because if you've gone to all this effort and you've been racking up legal fees from this phase onwards, and they pull out at maybe this phase here, the initial agreement phase, you will have then incurred a couple of £1,000s of legal fees because they've acted like an idiot. So if you can get them to agree to pay, or both sides agree to pay the other side's legal fees if one of them pulls out, then that's always a really good idea. But the rest of it isn't legally binding, but should be as comprehensive as possible. So if you're talking about timing, you're talking about earnouts or deferred consideration, you're talking about what exactly is involved in the sale, what's the agreement, how's it going to work, when are payments going to be made, who needs to give authority. If you've got multiple shareholders, you should get power of attorney for from each one of them, so you can act on their behalf. So you're not getting to the final sales date and suddenly you have to find all your shareholders from around the world to countersign an SPA, for example. You need to be very clear, and this is where lawyers who've done this many times before, like us, understand what should be in there and can cover all of these elements. If they are taking you on board as the founder, on what terms? If they are taking other people on board, on what terms? How will you be employed? What is the position? What will you be expected to do, etc.? Will you remain on the board? Will you continue to be a director, for example? All of these things have to be sort of pushed through. Once you've done that, you'll need to give clear instructions on who's doing what and whose lawyers have been appointed. We did a massive sale back in April and May where the other side, who were Americans, did not have lawyers. It was a flipping nightmare. It really was. So whatever as far as you possibly can, try and make sure that the other side have their own lawyers, because it's not a cost saving at all. It just ends up being ridiculously expensive and really difficult to manage. You've then got the due diligence phase. As I've mentioned, this is where the seller will ask for all this information. And if you can suddenly go, da-da, here's our data room, look how pretty it is. It's really nice. And look, it's all labeled and it's all good. And you can look at all of this stuff and look how clever we are and how organized we are. This is a massive tick box for any purchaser. They will go through it. They will ask lots of questions. Be prepared for them to ask lots of questions. You will need to draft a disclosure letter. So that's down the bottom, or rather not you, but your lawyers will need to draft a disclosure letter so that if there's anything in there that's anything in there that has not been disclosed or is a variation on that disclosure, then it will be in that disclosure letter. The purchaser will draft the initial sales purchase agreement, And then you've got the negotiation, and within there there'll be a whole heap of warranties. So for example, it might say that you have no tax outstanding liabilities. And if you did have an outstanding liability, like for example your council tax hasn't been paid yet, then that is what would go in the disclosure letter, because you're disclosing against those warranties. So for example, it might have, do you have a director service agreement? Or rather, the warranty might be that all IP has been assigned by all employees and directors to the company. Now, if you haven't signed a director service agreement assigning your IP to the company, you would have to disclose that. Now, the disclosure letter is normally the point at which there's a renegotiation about the price, because there'll be something in there. For example, if you haven't paid your council tax yet, then they'll take that amount off the purchase price, because they're going to have to pay it once they bought the business, if that makes sense. So you'll see a renegate. It's a bit like buying a house all this time. You know, things are disclosed and you have to vary the purchase price accordingly. You then prepare and complete and finalize all the documentation, and then obviously you've got, at the same time as the SPA and this disclosure letter is signed, you've got all of the company house documents that need to be done, etc., etc. Or if you've got land registry issues for an asset sale, that's when that would have to be done, etc. So at that point in time, there's also this post-completion phase where everything needs to be, most people are going to go, oh, it's done now, and completely and walk away and ignore it. At that point in time, that's where everything needs to be filed and sorted and done, and the whole data room is assigned to the buyer. So all of that information just goes straight to the buyer. So they've got everything in one place. And again, for them, having all of the documents and all of the information will massively help after they've bought the business from you. I'll just stop now to see if there's any more questions. Nope. I know I've cantered through a lot of this, but I'm just, you know, conscious of the time and to allow for questions afterwards. So these slides I can share with you, obviously, Nicola, and any of the due diligence stuff. But part of what's involved with MSKPN is obviously you've got the free online guides and tips and so on and so forth. If you need to talk to us, or you want to just reach out and just ask any questions about the sales or acquisition process, it doesn't cost you anything. You can give us a call anytime. Equally, if you need, we've got a free template HR pack that if you don't have your employment stuff all in place, we can provide all of that for you as well. So that's free from us to you guys to help support you. But what the biggest thing I probably think is that if you've got any questions about how the sales process works, or more crucially, that due diligence process, that foundational process, that is the bit that really makes the difference. So whether you're just buying a small practice, or whether you're buying a chain of franchises, that's the really key thing, is to be prepared as a business yourself, because you never know when somebody might approach you, want to buy you, or equally you never know where you might see a business and you might think, well, actually they're perfect, they're in a neighborhood town, actually this works, I can expand, I can build on my business, I can do this. The more care that they've taken about their business and putting all the right things in place, the easier it will be with you, and the lower the cost. So I'm going to stop talking now because I've gone through this massively. There are some downloads, as I mentioned. So you've got this due diligence download, whether it's for investment or whether it's for purchase, the same thing applies. But we've also done a business sale and purchase checklist, and we've also done the HR resource pack.
Thank you so much. There's so much information in there. Has anyone got any questions that they specifically want to ask? Otherwise, as you say, you've got the contact details if there's something more confidential that you want to have a conversation with Farringford Legal about. Just raise your hand or unmute if you want to jump in.
I think I've just cantered through absolutely everything.
No, it's good. It is a minefield if you haven't gone through it before, so it's useful for people. Probably obviously it depends on the thing, but as a rough, quite organized sale that progresses quite nicely, Can you give people a ballpark figure of what things cost?
So I think if you were to talk to most of my clients, they would say it would be a 10 to 20%. It depends if you're buying or selling. Okay, the two things, it depends if you're buying or selling. If you're buying, oh no, hang on, let me think about it. Sorry, if you're buying, it's normally 10 to 20% of the purchase price. If you were to ask most of my colleagues, I mean other law firms, with us, we would probably say it's 5 to 10%, so half.
Okay.
But we have very clear boundaries depending on the value of the business and what's involved with each one. So if anybody wants that, we can share it with you. But we have clear brackets. So so from 1,000 to 20,000, we have one fixed fee. 20,000 to 50,000, we have another one. 50,000 to 500,000, we have another one. Do you see how I mean? We've got very fixed. They're fixed fees, and all our fees are fixed. If you want to do it as an abort successfully, we can do that as well. But we tend to work out about 50% cheaper than most of our competitors.
I think it's good for just people to factor in that even if you've got a sale price, there's tax, there's legal fees, there's potentially broker fees, like just so you start to think about the fact that you're not going to get a gross figure.
No, it's not that. And the problem now with what a lot of people, we're doing a huge number of sales at the moment, because people are trying to sell before the budget comes in.
Yeah.
And because people are very worried that actually CGT might go from 28 to 45%. And if, as a small business, to suddenly lose almost 20% of your income, or not your income, what you expect, your sale price to the tax man is a massive kick somewhere that hurts. So there are a lot of people who are trying to push through sales at the moment.
Yeah, my stepbrother is a commercial lawyer and he's saying exactly the same thing. It's a very busy time.
Yeah, we're doing, I think we've got about 8 or 9 on all at the same time, all want to close before the 30th of October. And I think when you've got a focus like that, it does focus the mind and everyone wants to move on and get on with it. But where we're seeing the delays, it's really in the fact that they haven't prepared properly for the sale.
Yeah, that makes sense.
So
thank you for your time.
Yeah.
Any questions that people want to ask? No, well, you may have some people coming in contact, but as I say, we will share the slides. I've already had a look at the QR codes and things, so they're brilliant little checklist documents for people to work through as well. So thank you for those resources as well.
No, that's anytime. And really, anytime you need any information, it doesn't cost to just call us. It's absolutely fine. We're more than happy to just work through the questions that you might have, and more than happy to give you some guidelines as to what it might cost, depending on the value that you're looking at, and equally what might be involved.
Brilliant. Thank you.
No worries.
Thank you, everyone, for joining.
It's okay.
And catch up on the recording for those who haven't managed to join live. Thank you.
Thanks, Nicola. Speak to you soon. Thanks, Claire. Bye.
Bye.